Good afternoon, everyone. Thank you for joining us here today. My name is Valdi Lacoul. I'm a partner at Wigdor LLP, and I'm an attorney. And we're going to be talking today about the COVID pandemic and employee rights, and specifically accommodations and what rights employees are entitled to under the various accommodations laws. I've been practicing for about 25 years. My focus is on civil rights and specifically the protecting the rights of workers. I'm also an adjunct professor at Fordham Law School. And joining me here today is Taylor Craybill, one of my colleagues at Wigdor. How are you doing, Taylor?
Doing well, Valdi. Hi, everybody. Happy to be joining you today. Hope that everyone is doing well and staying safe. I've been with the firm for about 2.5 years now. Like Valdi said, we practice employment discrimination law, wage and hour, sexual harassment, Me Too. Certainly enjoyed the past 2.5 years. I look forward to discussing the COVID pandemic with you all today.
Okay. Great, thanks, Taylor. So as Taylor said, Wigdor LLP is a civil rights firm. It focuses largely on protecting the rights of workers who are victimized by discrimination, sexual harassment. We represent whistleblowers, victims of retaliation, and various other types of issues that come up in the employment context. We also represent people with disabilities and their rights as employees, and you'll hear a lot about that today during our presentation. Now, before we begin, I just sort of want to let everyone know that this presentation is just for general information purposes. It's not intended to be specific legal advice for a particular case. You may hear us talk about hypotheticals today. They may be similar to something that you've experienced, but if you want legal advice about your particular situation, you should go see a lawyer. This is not intended to replace that. So let me go over the agenda for today. First, Taylor's going to give us an update on the most recent pandemic and COVID status for New York. For employers and employees, specifically Governor Cuomo's recent guidelines on what's closed and what's opened and what will open, hopefully. I will then talk about the accommodations laws and specifically the Americans with Disabilities Act, how it applies in this day and age of pandemic, and what rights employees have. And then Taylor will then wrap it up with an update on the unemployment laws and various paid leave laws that apply here in the post-pandemic world. So Taylor, can you give us an update on what's going on with closures and openings in New York?
Yeah, sure. I'm just going to share my screen because we have a presentation prepared. Okay, great. So, as Valdi just mentioned, we'll be discussing Cuomo's 4-phase plan. And today's actually an exciting day because it is day 1 of phase 1. So it's kicking off the plan. Obviously, not the entire state is opening. There are only portions of the state opening, and then only select industries as well. As you can see on the PowerPoint here, Phase 1, which begins today, includes the industries construction, agriculture, forestry, fishing and hunting, manufacturing, wholesale supply chain, and select retail with only curbside pickup only. So, like I mentioned, the Phase 1 is starting today, and it is limited to only a couple of counties in New York. We have Central New York, Northern County, Finger Lakes, Southern Tier, and Mohawk Valley. So the rest of the state outside of those counties is still under the full lockdown, and only those counties are opening with the select industries. Obviously, there's going to be a lot of changes and updatings as things go on, kind of how we've all been involved with the pandemic so far. But a lot of the requirements and guidelines are still going to be followed, even though we're going back into opening up certain businesses, right? So, you know, some of the guidelines that the state has provided are something we're all familiar with, right? staying 6 feet apart, making sure you're wearing a face covering. But then the state is also putting out pretty detailed guidelines for each specific industry. So there may be specific industry related guidelines. For example, in construction, having one employee for every 250 square feet. That obviously be kind of specific to the construction industry. And even though they have only these guidelines for these select industries at this time, we anticipate that they are going to have these detailed guidelines for the other phases as well. If I just go back one slide here, just so you can look at the other phases and industries that are going to be happening in sometime in the future. For phase 2, we have professional services, finance and insurance, retail, administrative support, real estate, and rental leasing. Phase 3 is restaurants, food service, hotels and accommodations, and phase 4 is arts, entertainment, recreation, and education. Right, and so even though phase 1 is starting today in those limited counties and for those limited industries, we still don't have a timeline on when the other phases will happen. Obviously, once phase 1 is kind of completed and we keep hitting these metrics that the state and the governor are putting out, then more industries will open and we'll be moving on to future phases. Okay. All right, so once we start going back to work and we're following the guidelines that the governor and the state are putting out, your employer is obviously also required to follow certain guidelines. Like I said, making sure people are adhering to, they're staying 6 feet apart. Certain instances, making sure that in the construction industry, for example, making sure that workers have provided with face coverings. And so, of course, there's probably going to be situations where certain guidelines are not being adhered to, or there may be certain violations of guidelines, and there is a mechanism for filing a complaint regarding any violation. And you can certainly visit the New York State website in order to find out how and how to make that complaint. And I'm going to be sharing my screen to show you the website so that you are familiar with it and you're able to easily locate the certain area where you can make the complaint and where you can find the guidelines. So if you bear with me for a second, I'm just going to switch out to that website now. Okay, great. So here we have the New York State website on the phases for reopening. And overview here that kind of just goes through what I was just discussing in terms of the different industries that are going to be opening up and at which phase. Obviously, May 15th is today, and those are the counties that I discussed that are opening. And then phase 1, these are the industries. Now, if you scroll down, you'll see each one of the industries in detail here. So the website goes into a little bit more detail about who's included under this construction phase. And then you get a summary of the guidelines. You get a more detailed version of the guidelines and safety template down here. Now, of course, if you're in the construction industry, you can obviously feel free to review the guidelines, make sure that you are adhering to what is recommended by the state and the governor, and then also make sure that your employer is doing the same thing so that we obviously all are stopping the spread and making sure that we're staying healthy. Same thing for the other industries, goes into the summary guidelines, more detailed guidelines. And I would say even if you're not included in one of these industries and you're curious as to what guidelines may be applicable to your industry when it does open, you certainly feel free to review either the summary guidelines or the more detailed guidelines to be able to get a sense of what the state is proposing, at least for those industries, because there's likely to be a lot of crossover between the guidelines and what they're recommending. So once you get to the bottom of the page, it's the section for filing a complaint. Now, specifically, there's a general online form and a number for complaints, and that this could be for consumers. It's really for anyone. It's a 24/7 form, obviously, to file, and then the phone number as well. Now, if you're an employee, there's a separate form that you have to file on the Department of Labor's website. And so if we go to click on that form, it takes you to the complaints regarding COVID regulations, right? And it gives you a non-exhaustive list of certain things that would be grounds for a complaint. Obviously, if your employer is failing to pay you wages owed for you for hours worked, earn sick pay or pay time off, certainly you have a complaint about that. Your employer has threatened to fire you for reasons related to COVID-19. You qualify for sick pay, COVID sick pay, which we'll talk about later, and your employer is refusing to pay it. So just make sure that if you're an employee and you're specifically complaining about a situation with your employer, that you are visiting the Department of Labor website to file a complaint and not using the general form and the general number as well. Okay, I'm just going to hop back to our presentation. Okay, great. And then I'm going to turn it back over to Valerie to go over the disabilities law and accommodations as well.
Thanks, Taylor. Now, you referenced the Department of Labor. That was the New York State Department of Labor, correct?
That's correct, yes. If you're working in New York and you want to make a complaint about your employer, it's going to be the New York State Department of Labor, as opposed to the probably more well-known Federal Department of Labor. So definitely, yes, focus on New York.
Great, thank you. Okay, so right now, many of us are here in New York City. We're in a lockdown. People are working from home. But eventually, we're all going to start going back to work, hopefully in the not too distant future. And so what I'd like to talk to you about today is what that means for employees. What rights do they have? What can they ask for in terms of accommodations? And so what I'd like to do first is step back a little bit and talk about one of the landmark laws in this area, the Americans with Disabilities Act. And why it was passed and how it applies. Those laws, like the Americans with Disabilities Act, don't necessarily are not out of commission simply because we're in a pandemic stage. They still apply, and they provide important rights to employees. Now, what you should also know is that the Americans with Disabilities Act is a federal law. It applies to all employees who work in the United States, provided that the employer is large enough. But New York State also has a similar law that protects individuals with disabilities, and New York City does as well. They all have the same gist to them, which is essentially that you cannot discriminate based upon disability. There are some differences, but we'll focus on the larger one. But somebody in New York City, for example, is protected not just by the federal ADA, but also by the state and city laws. So that's important to know because there can be some differences. So anyway, everyone is familiar with laws in the United States that prohibit discrimination. I mean, these are laws that come out of our civil rights movement. Many of them were designed to prohibit race discrimination. They have since been broadened to prohibit discrimination based upon sex or religion, sexual orientation, or age. But one of the areas that did not get a lot of attention and enough attention was workers with disabilities. And there was a realization in the United States that was unfair both to the workers and to society. It's unfair to a worker, to an employee, to be denied job opportunities because of an underlying medical condition. for those folks to be sort of shunted aside and not be part of the workforce. And it's also unfair to society. We were losing as a society important people who could contribute, and they were just not given opportunities because of conditions, their medical conditions. And largely that was not because people had any animosity towards folks with disabilities, but because of stigma. There was a perception, a false perception, that someone with an underlying medical condition, a disability, was not as valuable as somebody without a disability. And just to give you a very simple example, if somebody has a mobility problem and is in a wheelchair, it doesn't make them any less capable of a lawyer or an accountant or a file clerk. And so those folks should be given the same opportunities. So if we can go to the, are we on slide 1? Yes, great. So the ADA was enacted to level the playing field and to make sure that employers provided individuals with disabilities equal rights in the same way that they would provide somebody equal rights based upon their race or sex or age. And that the idea was that workers should be considered on their merits and not be treated less well because of a disability. But the ADA and its comparable other laws goes even further, actually. It doesn't just require equal treatment, it also requires employers to provide reasonable accommodations to employees with disabilities. And what that means in the real world is that the employer may have to adjust the environment of the job to allow the person to do their job. So long as that adjustment is reasonable and not an undue hardship, the employer is required to do that. So let's talk a little bit about who is protected by the ADA and comparable laws. So Taylor, can we go to slide 2? Thank you. So first, an employee has to be qualified. Sorry, Taylor, can we just go one back? Great, thank you. The employee has to be qualified to perform the job, all right? An employee who's not qualified to perform a particular job is not covered by the ADA. So if a job requires an engineering degree, I'm not qualified for that job. I don't have an engineering degree, and I can't take the, get the protection of the ADA in that context. But somebody who does have an engineering degree and meets the general qualifications is protected. Secondly, the employee must have a disability. Now, disability is a term of art. Not every medical condition is a disability. Many are, but not all. So a disability is a medical condition that substantially impairs a major life function. So those are terms of art. And what that means is it's a medical condition that has an impact on your life, on your bodily function. Okay, so for example, hearing, seeing, breathing, thinking, taking care of yourself, those are all major life functions. A medical condition that substantially impairs any one or multiple major life functions is a disability and therefore qualifies under the law. Third, an individual who's qualified, has a disability, is protected so long as he or she can perform the essential functions of the job. Now, not all functions are essential. As we all know, there are things that we do in our day-to-day jobs. Some are core to the job, and others are kind of extraneous. We don't do them all the time. They're not as important. And so the ADA doesn't require an individual to do all of the job functions, only those that are essential to the job. Now, one good place to look to determine whether jobs functions are essential are written job descriptions. Some of you may get a written job descriptions when you either apply or get a job. But those job descriptions aren't the be all and end all. They can often be out of date. They can often describe things that are not core to the job. So what really counts is to the essential functions analysis is whether a particular responsibility or particular function is done routinely and is important to the job. And finally, in addition to being qualified, suffering from a disability, and able to perform the essential functions, the ADA protects those who can perform those essential functions with or without a reasonable accommodation. If you can do the job with a modification, then the employer must give you that accommodation. Okay, so let's turn to what accommodations are reasonable. Obviously, reasonableness is always in the eye of the beholder. An employee may think that a particular accommodation is reasonable, but the employer thinks it's not. So we have some ground rules. And the general rule is that a job accommodation is reasonable so long as the employer can make the accommodation without an undue hardship. And I'll get into the undue hardship part in a little bit. But a modification and an accommodation can be anything. Okay, it can be a physical modification to the workspace. So somebody who is in a wheelchair needs to have room to get to their workspace. That's a physical modification that could be reasonable. It could be buying new equipment, for example. An employee could have a visual impairment, and the employer might be required to give them a new computer screen, a larger computer screen. It can be a schedule adjustment. So an employee, for example, can have a condition that they take medication that makes it difficult for them to get up and running in the morning, and that's caused by the disability. And the accommodation could be a schedule change so that person can come in later in the day. Really, anything that can accommodate the person can be an accommodation. There is one case in New York where an employee was unable, because of mobility issues, to take public transportation to work. And the accommodation that was required was to provide that person with a parking spot in order to allow them to get to work. An accommodation could be work from home, and we'll hear a lot about that. I mean, there are many, many people working from home now as part of the pandemic response, but it can also be an accommodation for a particular job, for particular disability. And an accommodation can also be a medical leave. So an employee can ask his or her employer for a leave, a period of medical leave, so they can get better and return to work. Now, there's also a different law, the Family and Medical Leave Act, known as the FMLA, that covers leaves. And the FMLA is very specific. The FMLA says that an employee who has worked for his employer for at least a year and has worked at least 1,250 hours over that period of time is entitled to up to 12 weeks of job protected leave. And job protected leave means that that employee cannot be fired, demoted, or retaliated against in any way for taking that leave or asking the leave. But the ADA also plays an important role here, because there are employees who are not FMLA eligible. They may not have worked for the entire year and therefore not FMLA qualified. They may work only part-time and not have 1,250 hours. They would still be covered by the ADA and entitled to some type of leave if it's reasonable. Okay, so let's talk a little bit about the undue hardship prong. All right, so, oh, and by the way, there are no limits to the number of accommodations an employee can ask for. So an employee can ask for a leave, for example, ask for an accommodation of leave and say, look, I need a week or 2 weeks off from my medical condition. And then when that employee is ready to return, can ask for a second accommodation, which is, can I be allowed to return to work part-time for several weeks until I ramp up to a full-time schedule? So long as those requests are reasonable and don't present an undue hardship, the employer must make them under the law. So what is an undue hardship? Well, an undue hardship is not merely an inconvenience. It's not that it would make it more difficult for the employer to do the job, that it would make it inconvenient, that perhaps some employees may be put off or inconvenienced because one of their colleagues has an accommodation. It must be specific. There must be a specific undue hardship The fact that the employer has to spend money is not automatically an undue hardship. The employer may have to spend some money to create the modification, so long as it's not going to impact their operations. So large employers, think Walmart, think big box stores, large companies can obviously afford more in the way of accommodations than a small shop that doesn't have as much money. The other thing to be wary about during our times too is that a lot of companies are undergoing financial stress. So in determining undue hardship, that financial stress, the financial ability of the company is going to be relevant to the undue hardship analysis. Okay, so now I've just given you sort of the legal framework, but let's talk a little bit about some examples about where the reasonable accommodation, how it applies in our post-pandemic world. So let's say you live somewhere in New York, and we're in phase one, as Taylor identified. You're allowed to reopen and do some work. And let's say we're 2-3 months down the road, and the rest of New York is getting back open. But a particular employee who has been working from home successfully has a medical condition that makes that person immunocompromised. And that person is at a greater risk of getting sick because of their underlying condition. Under the ADA, the employer may be required to allow that employee to continue to work from home or telework, even if all of his or her colleagues are required to go back to work. That would be a reasonable accommodation if the employee can perform those essential functions of the job from the telework area. Okay. Let's say an employer requires employees to wear personal protective equipment, protective gear, face masks, gloves, certain gowns to do their job, but an employee has a particular condition that requires them to wear special gear, perhaps a special type of glove. An employer may be required to make that accommodation and get that special protective gear, even if that requires the employer to spend more money. Let's say, and we're in times where everyone is anxious and unsettled, but let's say an employee has a underlying psychiatric or emotional health condition like PTSD or anxiety or depression. And the symptoms of that condition are triggered by the pandemic. In other words, the person is afraid to travel, afraid to leave their job. And it's not just simply afraid, but that triggers an actual medical response. An employer may be required to modify that person's job and, for example, allow them to continue working from home so they don't have to travel, which would trigger their symptoms. Now, one of the things that's important to realize is that not an employee should ask for an accommodation, present an option to his or her employer, but the employee is not entitled to the accommodation of his choice. He is only entitled to an accommodation that takes care of the problem. If the employer can offer an alternate accommodation, then the employer has complied with its responsibilities, even if that alternate accommodation is less convenient. So for example, the example that I gave earlier of an employee who cannot travel, and let's say that employee cannot travel during rush hour. Either they're immunocompromised, or perhaps they have some underlying emotional health condition that gives them panic attacks if they're traveling during rush hour so close to the pandemic, and the employee has to work from home. Well, that is a plausible accommodation, but an employer can say to the employee, look, we're not going to allow you to work from home, but we are going to change your shift so that this way you work the late shift and don't have to travel during rush hours. And that would, so long as it accomplishes the accommodation and allows the employee to work, that would be a reasonable accommodation. But the best way to proceed is always to ask your employer for the accommodation and say, this is my condition, this is what I need, and make a proposal. And the employer is required to consider that. The employer cannot simply pretend it doesn't know about your condition and say, I'm not giving you the accommodation because I'm ignorant of the condition. The employee should ask. The employer has an obligation then to engage the employee and engage in what we call the interactive process, and go back and forth until an appropriate accommodation can be reached. Okay, so that's the general groundwork. Let's say an employer has, during our pandemic world, has a wonderful idea. And that idea is that the employer doesn't want to go through the hassle of making accommodations for employees. And it also wants to ensure that its workforce stays safe. So this employer has decided to get rid of any employee who could potentially get sick. So, for example, employees that have underlying health conditions or a history of underlying health conditions. Somebody, say, who has a history of treatment for cancer or has an immunocompromised condition, pregnant women, or employees who are 60 or over, because those folks fall into a more risky class of people. Can the employer turn around and say, look, I don't either want to hire those people that fall within those parameters, or I'm going to get rid of them? The answer generally is no. Okay, an employer cannot meet its obligations under the disabilities law by simply avoiding hiring people who are disabled, and it cannot rely on stereotypes, even if people are generally more susceptible to getting sick, to refusing to give them employment opportunities. And an employer cannot say to an employee, I'll give you the job so long as you guarantee you will not get sick. No one can ever guarantee that. And an employer is not allowed to discriminate based upon a stigma or a perception that somebody might get sick in the future because they've been sick in the past. So that's another important protection. The ADA also protects people who are associated with somebody who is disabled. So, for example, let's say that the employee is not disabled, but has a child at home that has special needs, or has family members at home, elderly family members who may be sick. An employer is generally not allowed to fire that person or take some other adverse action against that person because of their association with somebody who is disabled. Okay. The ADA also has a medical privacy protection provision. We're all concerned about medical privacy. People don't like to reveal their personal medical information, and the ADA covers that. And the ADA does not permit an employer to go fishing around through an employee's medical records unless it's important, unless it's necessary to assess an accommodation or evaluate a direct threat. So, for example, if an employee's employee in the workplace would be a direct threat, i.e. someone who has the coronavirus actively and may infect other people, an employer can get that information. Okay, so the employer is allowed to confirm the medical condition. An employer is allowed to learn how the medical condition affects the employee's ability to function on the job, to make accommodations. An employer is allowed to know that the person is fit for duty and that the employee does not present a direct threat. But the employer is not entitled to get the person's entire medical records. And the medical privacy provisions in the ADA depend upon where in the process you are in your job. And this is a really kind of quirky thing, but it's important. At the pre-offer stage, so at the stage when somebody is interviewing a candidate, the employer may not ask disability-related questions. And the reason for that is that the information that those disability-related questions may reveal could cause the employer not to hire that person. So if an employer says, look, I have 5 great candidates, I'm going to ask each one of them about their medical histories and determine who is most susceptible to getting to being infected with the coronavirus, and knock those people out and then just hire the person who is least likely to get it, that is unlawful. So the employer should be, may make an offer based solely upon the qualifications and not upon medical information. Once an offer is made, however, an employer can ask about a person's disability if it's necessary for the purpose of accommodating the person, or if it's a type of inquiry that's given to everyone. So let's say the job requires lifting, and an employer needs to know that this person is capable of doing something like that, the physical stress, and they put everyone through a test that is a lifting related medical test. As long as it's done for everyone and not just for people with disabilities, it's okay. Now, certain things are not disability related inquiries. Asking somebody how they're doing, asking somebody who has, the sniffles, whether they're okay, asking somebody if they're okay after a tragic event in their lives. But asking somebody to take their blood pressure or take their temperature. Now, taking their temperature is important here because generally you're not allowed to take the temperatures of employees. It's considered a prohibited medical test. But because of our current situation, revealing someone's temperature may be necessary to prevent a direct threat. It's now permitted under these circumstances, but generally it would not be permitted. Once a person is an employee and is working, again, the employer may make an inquiry so long as it's consistent with business necessity, and it's done for everyone else. Now, special rules apply here now that we're in this pandemic situation, which is essentially that an employer who makes a job offer may delay the start of an employee's work if that person is suffering from COVID symptoms. So rather than starting tomorrow, the employer could say to the employee, look, start in 2 or 3 weeks once you've been cleared and fit for duty. Conversely, the employee can turn around and say, look, I'm ready to begin, and I was supposed to begin tomorrow, but I have a medical condition. I'm suffering from COVID symptoms. I'd like to put off my employment for 2 or 3 weeks until I'm fit for duty. The employer may be required to do that unless the employer needs the person to start right away. In that case, the person would not be qualified or be able to perform the essential functions. An essential function would be starting tomorrow. Okay. Now, in any of these circumstances in which an employer is entitled to ask for medical information, they must keep that medical information strictly private. They must segregate it, keep it in separate files. It's not the kind of thing that they can share with the other employees. So it's supposed to be kept confidential. Now, all of these rights are well and good, but what about those employees who are afraid to ask their employers for an accommodation or for a leave because they're afraid they might get pushed back, or they might get fired or demoted or denied a raise or a bonus? Well, the ADA, as well as the FMLA and the local laws, also prohibit retaliation. So if an employee goes to the employer and says, I need this accommodation, the employer is not permitted to retaliate against that employee for asking for the accommodation, even if that accommodation is not granted. The employee is entitled to be wrong. The employee can ask for something, not be entitled to it, and still be protected from retaliation, so long as they had a good faith belief. Similarly, if an employee thinks they're being discriminated against because of their disability, because of disability as it relates to COVID, they are prohibited from, the employer cannot retaliate against them for asking for accommodations or for saying that they are the victim of discrimination, even if that person is wrong. They're allowed to be wrong. So it provides a protection for people to be able to let their employers know of their concerns, ask for things without being retaliated against. So hopefully that gives you some good insight into what the rights are for folks with disabilities in the current situation under our current laws. And with that, I'm going to kick it back to Taylor, who's going to talk a little bit about unemployment insurance and paid sick leave.
Yeah, sure. And we actually got a question, Valdi, so maybe we'll jump into that before moving on.
Sure.
Yep. So question is not necessarily specifically related to disabilities law or accommodations, but let's say, for example, the person was laid off, and they were the only person at their company laid off, while the other people were, only provided with the salary reduction, but otherwise retained. Um, and I guess the question is, what are some of the reasonable grounds for termination? And I guess conversely, what would be protected, in terms of categories of individuals, um, or any other category that might be an unlawful reason to kind of terminate somebody.
So most employees in New York is what we call an at-will state, which means an employer does not have to have a reason to fire people. An employer can fire any employee for whatever reason it wants, or no reason at all, or even a bad reason. They're allowed to, as I tell many people, to run their company into the ground, get rid of good people for no reason. They're allowed to act arbitrarily. What they can't do is lay people off because of protected characteristics. So in the hypothetical, the question was, everyone else gets a job, gets a pay cut, but this particular employee is actually fired. Well, you would look to see whether or not that particular employee is some way different. So let's say that the employer kept all the men but reduced their pay, but fired the one woman, or kept all the people, all the people of a particular race or national origin, and fired someone who was not of that same race or national origin, or kept people of particular religion. That might show that the reason for the person getting fired, or the reason that person was picked, is because of that person's protected characteristic, which would be unlawful.
Got it. Thank you. And just for everyone out there, feel free to send in your questions. We'd much rather this be kind of a discussion about your questions than us just presenting. So obviously, feel free to jump in with any questions at any time. All right. So, like you said, we'll turn now to the unemployment benefits, and I'm just going to reshare my screen so that we can get into that presentation. Okay. Okay, we covered that. Okay, so who is eligible for unemployment insurance benefits in New York? Now, before the pandemic, as many of you probably aware, if you lost your job through no fault of your own, if the business folded up for whatever reason, or any other reason that wasn't related to yours, and then yours having the employment end, then you would qualify for unemployment insurance, and you would submit that application to the state, and then you would be paid a certain amount of weeks pay in lieu, while you try to find additional employment. Now, obviously, since we're in the middle of the pandemic, there have been certain laws that have been passed to help people, right? We're all sheltered in place. Obviously, today's day one of the beginning of the reopening, but for large majority of us, we're still hunkered down and still practicing, safe guidelines, stay-at-home orders. So that has obviously affected many, many people in not being able to work. Not many people, or a large number of people, are unable to perform their jobs remotely or from their houses. So the government has stepped in to provide additional benefits for circumstances related to the pandemic, not just you losing your employment through no fault of your own. Okay, so in order to be eligible for these benefits, you need to be unable to work because of the coronavirus pandemic, and you need to fit into certain categories, right? So you're unable to work for the pandemic, and you're self-employed, you're an independent contractor, you're a gig employee, farmer, you're diagnosed with COVID-19 or you have symptoms of COVID-19, you're unable to reach your place of employment, like I mentioned, because you're unable to work remotely. Or even if you quit your job because of the coronavirus, if you need to, unable to perform your job duties because you are now the primary caregiver for your child, right? These are situations that you're now allowed to be able to get benefits for related to the coronavirus pandemic. Now, but if you are able to work remotely, then that would be a situation where you're not qualified. So if you're able to telecommute, if you're able to perform your job duties from home, then you do not qualify for the unemployment insurance benefits. Now, same thing for those benefits in terms of applying. You're going to obviously want to go to the New York State website and go through the process of applying for those unemployment benefits. And like you saw earlier with the going through the phases and the different information that's available, those websites obviously have the same kind of information related to uninsurance benefits. So feel free to go through those websites, and if you have any questions about unemployment insurance benefits, hopefully that can certainly answer them, and obviously you can feel free to answer those. We'll be happy to answer those questions to the extent we can as well. And if you do visit the New York State website, you'll come across this chart, and this chart goes through the categories of where you would be covered to obtain unemployment insurance benefits, and where you wouldn't. And obviously the covered categories there are some of the ones that I just went over. And then you'll see down here where you're unable to obtain the benefits, telecommuting is there, you're receiving paid sick leave or other benefits. That also would be a situation where you wouldn't be entitled to receive the unemployment insurance benefits. Okay, and then now we kind of want to jump into paid sick leave that's available. And so your employer is under the new laws, obviously related to the pandemic. Certain employers are required to provide paid sick leave in connection with the pandemic and having to, not being able to work. And so you'd be entitled to receive the paid leave if you work for a company with more than 10 employees, or the company or business makes over $1 million in net income for 2019. In those situations, if that criteria is met, then the employer is required to provide you with the paid leave. Also, if you work for a public employer. And you or your minor child are under a mandatory or precautionary order, that's also a requirement. So go to the next slide here. How many paid sick leave days am I entitled to? Again, it depends on the employer size. So anyone 10 employees and under is going to, they're going to be exempt. They don't have to pay the paid sick leave, right? But for employers with 11 employees and then make less than $1 million in net income, then they are going to have to pay for the paid sick leave days. I believe it's 5 paid sick leave days. If it's a situation where it's an employer with 11 employees and over $1 million in net income for 2019. For private employers with 11 employees to 99, it's also 5 paid sick leave days. And then for private employers with with 100 or more employees, then it's going to be at least 14 days of paid sick leave under the law. And then for public employers and public employees are entitled to 14 days as well in terms of the amount of paid sick leave that you would be entitled to. Okay. So what documents do you need to apply for the paid sick leave? So you'll need a mandatory or precautionary order of the quarantine that's issued by the state of New York, the Department of Health, local board, or any government entity authorized to issue that order. And you can obtain, you're also going to need the paid family leave. It's form PFL-1 and a request for COVID-19 quarantine DB//PFL. So you can get those forms from your employer, or you can get them from your employer's insurance carrier. And you can also find them on the New York State website. So if you feel that you fit into the criteria where your employer, meets the thresholds in terms of having to provide paid sick leave in connection with the COVID-19 pandemic, certainly look into that and make sure that you are going online or asking your employer for those forms so that you are taking the necessary steps in order to meet the requirements to be able to receive that paid sick leave. Okay, we just went through that in terms of obtaining the documentation for mandatory precautionary order. So one question that often comes up is, do you qualify for sick leave if you're able to work remotely? And, as we just went through, as we saw in that chart provided by the New York State, then if you're working remotely, you're able to perform your job function, then that's going to be a situation where you're not entitled to receive unemployment insurance benefits. So that's kind of a breakdown, high level, of the paid sick leave law. If you have any questions about that, certainly feel free to write into us.
Great, thanks, Taylor. That was great. And it's just important. One thing before we sort of sign off here, I mentioned the FMLA before, the Family and Medical Leave Act. The Family and Medical Leave Act does not provide for paid sick leave. The Family and Medical Leave Act simply provides for job protection. So it says an employer cannot fire you for taking leave that is up to 12 weeks in a given year. But New York's law, which was enacted specifically in response to COVID-19, actually allows for paid leave. But as Taylor said, that law kicks in generally only if you are unable to work. So if you're able to work from home, you're not qualified. But if you're not able to work from home or can't work from home, then you may be qualified. So again, you can give us a call about any of these things, and we'll be happy to answer any questions that you may have about this. So with that, I think we are done for today. Thank you all for tuning in. Taylor, thank you for that informative presentation, and we'll see you all next week.